Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today.
And it is true, right? You're on this email, correct?
Yes.
And on April 21st, 2022, which is after the search of the prop house, you and the team sent the firearm for testing at the FBI, correct?
Yes.
I apologize. I think I've been handed the wrong thing. Can we approach?
She can have my copy. I'll take yours then. If you want.
Hang on. We need to approach. May we approach?
Yes.
That little clip right there is a microcosm and a fairly demonstrative exhibit of how badly the cross-examination of the CSI went for the state yesterday. And it's also an example of, you can see how much stress this is causing Ms. Morrissey as her interactions with the judge become a little bit more strained than they have been previously. I know you've all heard me say it before on this channel. There is a tendency among trial lawyers to try every case the way they tried the last case that they won. And this is a good example of that right here in this case. The last case this prosecutor won was the Hannah Gutierrez Reed case. In that case, it was necessary to bring in pretty much all the evidence in order to show the chain of custody and show who might have had access to the live rounds, who loaded the gun, where were the dummy rounds, how do you distinguish between a live and a dummy round. All of those things were relevant because those were critical to her negligence. Other than perhaps being relevant on the issue of him checking the gun, the issue of the live rounds and the dummy rounds is less important in this case. And even though there were a lot of unanswered questions in the Hannah Gutierrez Reed case, the evidence that was presented there was for the most part strictly necessary. In that case, the negligence asserted was not checking the gun and not ensuring that the rounds in the gun were not live rounds. In this case, the negligence doesn't hinge on whether they were live or not, because he violated the rules of gun safety. The negligence hinges on the operation of the pistol, and that was in the sole control of Alec Baldwin. As you may have seen if you watched the entirety of the police officer's videotape, Alec Baldwin walked up and blurted, "I was holding the gun." Now, you'll notice he didn't say, "I shot Helena Hutchins." Essentially, he tried to blame the gun. "I was holding the gun and it just went off." Of course, everyone who has ever operated that type of pistol or who's done any research whatsoever understands that's all complete nonsense. It's just bunk. While the chain of custody of the pistol after the shooting is important, the prosecutor here could easily have established that through the CSI with a very few questions. She could have established the condition that it was received in, who it was received from, and they could tack it back to Baldwin having had possession and his admission that he was holding the gun when it supposedly went off. So all of those things are relatively quick and easy to get in and get out with on this particular case. But again, because she's trying this very similarly to how she tried the case against Hannah Gutierrez Reed, that's not what she did. Now, while you have to rule out with an expert that the gun didn't just go off and that Baldwin pointed it at her and pulled the trigger, those are really the only operative facts that establish negligence here. But instead of getting in quickly and getting out, the prosecution spent a lot of time with the CSI witness on day one. So on day two, the defense is returning the favor with the mission of proving the CSI incompetent in her job. And sadly, he largely succeeded, although her incompetence did not affect anything that's really relevant to the negligence in this case. But still, we were treated to this.
You also recovered Miss Hutchins' cell phone, correct?
At a later date, I believe.
And that was sent to Byron French and the investigation division to extract the cell phone results eventually, correct?
I believe so, yes.
Now, you tried to find video recording in the church, correct?
Yes.
But the video cameras for the scene in question did not record that day, so you were not able to find that. Fair?
They recorded a portion of that day. There was a recording that was recovered.
And you didn't find any live ammunition in the church?
Yes, there was one live round located inside the church.
There was, okay.
So ask yourself, what do those questions have to do with Alec Baldwin and what he did? Because that's really the issue on trial here. What did he do? Why did he do it? What effect did it have? How does any of this help excuse what Baldwin did? Her cell phone? You're asking about her cell phone? Why? I guess the video part that he asks about is potentially relevant if it had captured the shooting, but it didn't, so it's not relevant. What he's doing here is he's leading her down the primrose path. He's setting her up to look bad. Not convinced? Watch this.
You have to figure out how ammunition works on a movie set, right?
Yes.
That wasn't something that you were familiar with before the incident in question, right?
Correct.
And you sort of became the subject matter expert on that topic, right?
Yes, I'd say so.
Right. I mean, you were
For
called
the sheriff's office.
for the sheriff's office, right? But also you'd be called into meetings with Corporal Hancock and the prosecutors and try to educate them on those topics. Isn't that fair?
Yes.
Okay. I mean, you weren't running the case, were you?
No.
But you were there to assist not only with the evidence, but to be a specialist on this sort of unique topic. Fair?
Yes.
Yeah, he's setting her up. She doesn't even realize it. This fits nicely into the playbook for cross-examination. You always start out so sweet, butter wouldn't melt in your mouth. Why, you're a professional. I really respect what you do. You know, you have a hard job. You set up the pins, and then you roll that bowling ball down and you knock them all down. And you may not even be satisfied with just knocking the pins down. You may want to crush them. But again, why does this matter? Ask yourself, did Baldwin check the gun? Well, we know he didn't. So whether he knew what a dummy round looked like or not doesn't matter if he didn't check the gun. It's really irrelevant. And the judge is letting the defense waste time with this jury here on all of this stuff that is not directly relevant on the issue of negligence. So we spend a lot of time on the issue of dummy rounds. Watch.
And again, you said this on direct, but I think it got a little confusing perhaps. But there are never supposed to be live ammunition on a movie set.
Okay, go ahead. Yours is on though, right?
Yes, it is.
Okay.
Thank you. You understood that there should never be live ammunition on a movie set, right?
Yes.
And the one type of ammunition that occurs on movie sets is blanks, and those are the ones that just go poof, right?
Okay, I'm going to stop the bleeding here a little bit. We're going to advance a little bit forward here just to show you what's going on. So we've now burned through more than 10 minutes of trial time about the dummy rounds that have absolutely no relevance, and while it's irritating that the defense is doing this, it's really the fault of the prosecutor for not paring down her case to the lowest common denominator prior to trial. The remainder of this cross-examination was largely very effective, generally, and it showed that the scene wasn't properly preserved, which, in a whodunit, might be important. If the question was whether or not Colonel Mustard killed, the major in the library with the poker, and they didn't secure the crime scene, that's important in a whodunit. where there is some doubt as to who actually did the deed. There's no doubt here. He admitted it. If there was some doubt about who fired the fatal shot or what gun was used or who loaded the weapon, then all of this might be relevant. But we know that Baldwin admitted to the relevant act by way of his statement that he was holding the gun. And just so you know, that statement irritates the heck out of me because, like every other gun owner, I know guns don't have a brain. Arguably, neither does Alec Baldwin after he gave that interview with Stephanopoulos. But because they don't have a brain, they don't act on their own. They only act on input from humans. Now, you should be asking yourself why all this matters here and why this very experienced lawyer is doing all this arguably irrelevant stuff. Well, I'll explain it. It relates to what's called the CSI Effect. And when we say CSI, I don't mean your garden variety crime scene investigator. I mean the show that was on CBS for several seasons. And I'm sure we all remember that show originally set in Las Vegas. And then, of course, they also brought it to Miami. And they called it Miami CSI. I always liked the guy that was sort of the lead character in that. You know, he'd walk out of the building and there'd be the bright sun blazing down from Miami and he'd put on his shades and he'd look cool, you know. I wish I could look that cool even just once in my life. But, you know, you can't have everything, right? That show, both the Vegas show and the Miami show, featured lots of simulations and science and animations and reenactments. And there were lab tests, DNA, all that kind of stuff. And it was all in service to putting the bad guy in jail or figuring out who the bad guy is, who should go to jail. The reason this is so damning here in this case is that the show CSI demonstrated fictionally what a jury should expect in a criminal case, even though there is a huge difference in budget, in the fact that they're on a soundstage in Hollywood, they're creating a fictional crime and a fictional drama about that crime, and we're dealing here with a real-world police department, sheriff's department, real-world crime scene, real dead body, all of that stuff. Having set the standard on that show for what a jury ought to expect, CSIs were held in pretty high regard after that. In fact, I'm sure that the number of people entering into forensics as a profession increased a lot as a result of that show. But here you have a trial lawyer who is slapping around the CSI like she's a misbehaving mutt. And he's showing the jury that they really can't trust anything that she says or the state says. As I said earlier in this case, the solution to this is in closing argument. But if you've structured the case better at the outset, limited your exam, and objected frequently to the relevance of this information, thereby alerting the jury to the red herrings, you'd be in a lot better shape at the end. Ideally, I would have put on the first witness the state did. I would have put on that police officer. I would have let him lay the groundwork and set the stage for what's going on. Then I would have brought in the CSI, and I would have put her on solely to establish the chain of custody with a firearm and anything that was directly relevant on the issue of negligence. Then I would have moved to the witnesses to the actual shooting. I would have had them in there to tell their stories. Did they see him pointing the gun at other people? Did they see him gesturing with the gun? All of that. I would have laid the foundation for the admission of all of the video that was filmed around the set, including him pointing the weapon at different people. And then I would have brought in my experts to lay the foundation for recklessness. I would have brought in my expert to lay the foundation for how the pistol operated. I would have brought in the FBI expert to talk about the testing and why they did destructive testing on this firearm and whether or not it was intentional or not. And then I would have finished the case with the set medic who testified so brilliantly in that Reed case and amped up the emotion in that case. That would have made this line of attack by Mr. Baldwin's counsel a lot more difficult to pull off because the case would have been streamlined and it would have been focused solely on his actions at the time of the shooting. Unfortunately, that's not what happened. And as a result, we're being treated to these long and arduous cross-examinations. And I am pretty sure that the jury is getting tired of listening to that New York accent from Alex Spiro. I'm sure they're wondering when he's going to slow down a little bit and talk like a normal person, but that's probably not going to happen. This is an interesting case. I think, like I said, I would have probably handled it differently if I'd been in charge, but I wasn't. So, my opinion, and $5 probably gets you half a cup of coffee at Starbucks. So that's what I have for you today. If you have the opportunity today, do something nice for someone. It doesn't have to be a big thing. When I worked as a respiratory therapist, one of the hospitals that I worked in absolutely refused to buy ink pens. They made it a requirement that nurses and therapists and everybody else brought their own ink pens to work so that they could chart. The only problem with that is that no one ever had an ink pen, and they were always filching someone else's ink pen to do their charting. So one of the things that I did from time to time was bring in a big thing of Bic pens for people when they ran out of ink or when they needed a pen. They could go back to the workroom and grab a pen and take it with them. There are a lot of things like that that you can do in the course of an ordinary day that make other people's lives better. And when you make other people's lives better, you make your life better. And also, don't forget to be kind to yourself every now and then. It's okay. Get a larger size Coke as opposed to the small one. You deserve it. Be kind to yourself. After you've done some kindnesses, maybe to yourself, maybe to others, come on back tomorrow. Join me down here at the beach, and let's talk about something else interesting. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.